All right, welcome. Many of you have been following the case of the family court judge in West Virginia who was caught on video searching my client's house against his objections, threatening to throw him in jail. There have been two actual pending cases in that situation. There's been the judicial disciplinary case, which was pending before the state Supreme Court, and then there's the federal civil rights lawsuit that we filed that's pending in federal court. So late last week, there was finally a decision that was issued on the judicial disciplinary case, which censured the family court judge for engaging in the search and leveled some sanctions of misconduct, and ultimately opined on whether this was a search or it was a so-called home view or view as the judge's defense was. And as I'll explain, I think that might be relevant to the federal case, in which he asserted judicial immunity. So for those of you who haven't seen the video, let me go ahead and bring that up and show it to you. So this is a video that was taken at my client's house. Really, it was in the middle of a family court hearing, a petition for contempt that was filed about a year after his divorce, where the judge, during the ex-wife's testimony, just said, "All right, well, what's your address, ex-husband? We're going to be at your house in 10 minutes. Be there." And he was recording on his person, and he had his girlfriend recording this video.
Right now. You just hit yours.
Got an audio.
Laughing ain't good. It's all laughs and fun for them.
Can we, hey guys, I need you off my property, please. Hey, you ain't allowed on my property. The only ones allowed right now is the judge and the deputy. Step off the property.
Yeah.
Step off the property. Judge, can I ask you something real quick before we get started? Judge, can I ask you something before we get started? Can you come here? I ain't trying to have everybody else listen.
Well, Mr. Luck gets to listen.
That's good. I'm asking you right now, I'm putting in a motion to recuse yourself because you're putting yourself in a witness capacity instead of a judiciary capacity. There's no search warrant. I need a list of everything that we're looking for.
You've got a list of everything that's worked for it's attached
Not
to
today.
the order.
Not today. I don't know where someone was at.
Well, we're going to find
You got it?
Your motion's denied. It's not timely filed.
I need a search warrant. You won't get in my house without a search warrant.
Oh, yeah, I will.
And on that order, ma'am, it says swing. These are two separate purchases.
You can't argue with me while I'm doing this. Okay?
Sorry. Order's the order.
I'll have to think about that because that's pretty permanent in. That's not bolted down.
It is bolted down, all four legs. It is absolutely
It's
bolted down. Yes, it is.
So I have to think about that.
Ma'am, step off. I don't need you in my land. Please go that way. Please go away.
She's entitled to be here. Now, you're either going to let me in that house or he's going to arrest you for direct. Are you recording this?
Yes, ma'am.
Take his phone. You're not allowed to record this.
Don't take my phone, sir.
Okay, so he's forced to turn his phone
I'll
off.
take you to jail if you don't turn them off.
Still recording the audio. I'll take you to jail if you don't turn it off. You understand that?
Yeah, put it up. Give him the phone. Or are you going to be arrested?
I can record on my
You
land.
cannot.
This is my land, ma'am.
I am the judge trying to effect equitable distribution.
Here.
We are having a hearing.
Okay. Go on.
Now, you let me in that house, but he is going to arrest you for being in direct contempt of court.
I don't think the phone's off tonight. I think it's off.
I just turned it off.
So I'm the judge trying to effect equitable distribution. You're going to let me in your house or you're going to go to jail. And you can hear the bailiff.
No, my phone's not off.
The bailiff is
It's on.
radioing
The recording's off.
backup where 2 other deputies show up, and they all became defendants in the civil suit. All right, so then they go inside and they search the house. Okay, so the judicial disciplinary authorities ended up performing an investigation, taking a statement from the judge, during which she was unable to provide any legal basis upon which she could go do these things and search the house of a litigant. But she admits that she had been doing it for 20 years. And, nobody had really objected to it before. She ends up getting charged via a formal statement of charges. She enters into a plea agreement of sorts, and then it sort of goes haywire. The Family Court Judicial Association then sort of backs her up. They try to get the prosecutors fired. It was a big dramatic mess. Ultimately, it went to the Supreme Court, and that's what came down here late this past week. Is the Supreme Court finally ruled on this and ruled that she was wrong in what she did. And I'll bring it up here. Let me share the screen. Okay, so this is the actual decision that came from the Supreme Court here late last week. We begin with a threshold question, and this is because the judge's defense is that she thought she had the ability to search the home of parties in the divorce before her, even though the divorce had already been finalized a year earlier. The ex-wife was claiming that she still had stuff she didn't get that she believed was inside the house. So was this a view or was this a search? And this is according to the West Virginia Supreme Court. Did the judge view the ex-husband's home or did she search it? We find that she searched it. Then they go on to define what a view is. And then they go on to define what a search is. So basically, with a view, that's if there's something that's completely immovable and inconvenient to produce in court, the court can be brought to it. So they say, yes, the husband's home is immovable and certainly inconvenient or impossible anyways to produce in court. However, this is the important part here. The judge did not go to the property to observe the ex-husband's house. She went there to locate and seize contents inside, pictures, DVDs, other items of personal property. So those things weren't immovable. So it's not really a view situation. She didn't go to view, she went to search and seize. So the record's clear that the judge went to the property to locate things, not simply to observe them. And in fact, you heard her on the video, and that's what the Supreme Court says here. You have a list of everything attached to the order. When the ex-husband professed not to know where some of it is, she replied, well, we're going to find it. What is that but a search and a seizure? So according to the Supreme Court here, looking for things is a search by any sensible definition of the term. Then they go into some United States Supreme Court case law here, Terry versus Ohio, on what exactly a search is when the Fourth Amendment is implicated. And they conclude that was implicated here, that this was a search. And then they go on to really the important part for my purposes here. What is a search? Do judges search? No, judges don't search things. So according to if you don't believe me, here's the West Virginia Supreme Court. Searches are an activity of the executive department. Okay. Indeed, searches are so quintessentially executive in nature that even a judge who participates in one acts not as a judicial officer, but as an adjunct law enforcement officer. Okay. That's nothing new, as the court points out here. To say that searches are an executive activity is to announce no new principle. The Supreme Court dealt with this in 1979 when it rejected a conviction resulting from a search led by a town justice. According to the Supreme Court, the town justice in question allowed himself to become a member, if not the leader, of a search party, which was essentially a police operation. The Supreme Court found that in so doing, the town justice was not acting as a judicial officer, but as an adjunct law enforcement officer. Okay. It's a 1979 Supreme Court case. Even if a judge is a judge, when the judge goes to a house and searches, the judge is not a judge anymore. The judge is not acting as a judicial officer, but as a law enforcement officer, regardless of what the actual title is at that point. So other courts, the Supreme Court found, routinely assume that searching is a law enforcement activity, and they actually go into the West Virginia Constitution. So under our system of government, judges may not exercise executive power. So we have separation of powers, legislative, executive, judicial, and they all have to be separate and distinct according to the West Virginia Supreme Court. The Constitution further specifies that no department shall exercise the powers properly belonging to either of the others, and forbids any person to exercise the powers of more than one of them at the same time. In light of these clear prohibitions, here's the crux of the matter. We hold that the West Virginia Constitution forbids a judicial officer to participate in a search because a search is an exercise of executive power. West Virginia Constitution, Article 5(1). Because Judge Goldston plainly engaged in such a search, we find that the so-called view, as she called it, was improper. And then they go on to explain how she violated the Code of Judicial Conduct in so doing. All right, so that's the West Virginia Supreme Court decision that just came out last week. Now that is a done deal. That there's no appealing that. That, at least not unless she's going to petition the U.S. Supreme Court, which is unlikely. This is West Virginia state issue. Now let me take this out. Let me look now at the second case, the federal civil rights lawsuit. What is the judge's defense been so far? Well, of course, she's filed a motion to dismiss, asserting judicial immunity. I'm a judge, you can't sue me. So let's take a look at what she filed there. All right, so this is her response. All right, so, no, that's not it. All right. According to her own response, there are only two sets of circumstances in which judicial immunity is overcome. First, a judge is not immune from liability for non-judicial actions, i.e. actions not taken in the judge's role as a judge. Second, a judge is not immune for actions, though judicial in nature, taken in the complete absence of all jurisdiction. So those are the two situations which even they admit is, can cause a judge to lose judicial immunity. So a judge, again, according to them, a judge will not be deprived of immunity because the action he took was an error, was done maliciously, or was in excess of authority. So whether an act by a judge is a, quote, judicial one relates to the nature of the act itself, i.e. whether it's a function normally performed by a judge, and to the expectation of the parties, and whether they dealt with this judge in his or her judicial capacity. All right, so that's their motion to dismiss. However, they might have a problem here because the Supreme Court just blew that out of the water, basically, that this was not a judicial act. That what are you doing when you go and search? That is an executive act. That, even citing the Supreme Court from 1979, that becomes an executive act that becomes a law enforcement act. So really, as I argue in our response here, is, we have both of those things. So we have a judge engaging in non-judicial actions, which were taken in a judicial capacity, engaged in functions and behaviors that were not normally performed by judges at all, never performed by judges, wholly outside the expectations of litigants in a family court. When a judge is personally participating in and directing a search and seizure inside somebody's home, they should not enjoy judicial immunity for that sort of situation. Let's see. So if one is going to assert judicial immunity, the burden is on them to basically prove their case of why they get judicial immunity. So what they did was cite the Morales case. And that's the case where the judge asked the bailiff to go get a lawyer who was in the courthouse, who had a case pending before that judge. And when you go get them, use excessive force when you do it. So that was done, apparently. The lawyer sued the judge and sued the bailiff, I believe, And the judge got judicial immunity because they said basically, well, yes, it was a violation. The judge should not have done that, didn't have authority to do that. It was still a case pending in the courtroom. The judge was there sitting on the bench. It was close enough. Now, just an interesting aside, the bailiff did not get to assert the judicial immunity of the judge in that case, but only got qualified immunity. So we'll see if that holds up the same way in our case, where the police officers involved also were sued. Now, to determine whether a judge performs a judicial act. So that's really the crux of the matter here, is if a judge is, even if they're exceeding their power as a judge, even if a judge is not allowed to do that, so long as they're performing a judicial act, even if wrong, even if a violation, then they still get immunity. So how do the courts decide whether or not you have a judicial act? Well, to determine this, courts consider whether the judge engaged in an action normally performed by a judge and whether the parties dealt with the judge in her judicial capacity. That's from that case. So in that Morelli's case, with the excessive force case, the defendant judge became angry at the lawyer who was absent all morning from, when he was calling, and said to the bailiff, forcibly and with excessive force, seize and bring that lawyer into my courtroom. So the court noted that in that case, you had a judge's direction to court officers to bring a person who was in the courthouse before him is a function that is normally performed by a judge. And ordering a battery has no relation to a function normally performed by a judge. That was the dissent of Justice Stevens in that case. And that's a good point. But that's sort of the gray area is calling a lawyer a judicial act, even if you say do it in such a way as you commit an excessive force violation. A majority of the court found that was a judicial enough act to trigger judicial immunity. However, Stevens was in the minority. He found that ordering a battery is really what's at play here, and that's not something normally a judge does. So what do we have here? We have allegations that the judge personally engaged in and directed a search and seizure inside the plaintiff's residence, along with 3 law enforcement officers, which actually did result in the seizure of items of physical personal property. Well, the search of items, so they were going to locate the items, and then they seized items, actually removed items from the property. So we have a textbook really search and seizure here with the police. That really, can there be any doubt that was not a judicial act, was rather a purely law enforcement act? Even though there was a pending case that had a case number, the parties were the same. We were in the plaintiff's, in the litigant's living room, and with the judge personally directing a search and seizure. So as the West Virginia Supreme Court really made clear, this was a law enforcement act. This was an executive act, which actually violates the West Virginia Constitution, much less the federal Constitution. So the West Virginia Supreme Court, I believe, really completely shot that out of the water. Now, that motion to dismiss based on judicial immunity is still pending before the federal court, though the litigation continues. The federal court, I guess, could rule at any time. But here we have from the highest court of the state of West Virginia that there is no right of a judge in the state of West Virginia to go and search and seize inside an individual's house and be able to claim that it's a judicial act. There's no right within the rules, statutes, whatever case law in the state of West Virginia, which allows any judge, much less a family court judge, to do that. And that's what they were pushing for. Again, the Family Court Judicial Association here in West Virginia filed an amicus brief arguing that family court judges in West Virginia, since they're both the judge and the jury, so to speak, because there are no juries in family court, and they're the finder of fact, and they're also the judge in the case, that they should get to go and view just like they were a jury. However, there's a lot of problems with that. So judges issue orders, law enforcement affects the seizures if it's a search warrant or some sort of seizure order. And that's the proper way things are done here. So we don't have judges actually going to people's personal property and directing a search and seizure with law enforcement there and saying, all right, well, this guy's going to arrest you if you don't comply. So the disciplinary case is over. That's in the books. We had a censure, which is the strongest possible condemnation that could come from the West Virginia Supreme Court about the misconduct of a judge. And then we have the pending civil rights civil lawsuit, which is pending in federal court in the Southern District of West Virginia. So that case goes on, and we're now going into the discovery phase, and look forward to working that case up and proceeding towards trial in that case. So that's pretty much it. That's the update. So thanks for watching, and I will see you at the next update.
Oh,